Good evening, this is John Milburn for Laws 12063, Advanced Statutory Interpretation and Drafting. This is week 6. The topic for this week is Principles and Practice of Plain English. This is a wonderful topic because it gives me yet another opportunity to get on my high horse and to promote some of the things that are very close to my legal hut, if you like, in terms of how we go about communicating in law. Speaking of communication, I just want to share some contributions which have been provided by students, one of whom is here tonight live. So let me share the screen and look at these contributions that have been provided by students in the unit. So the contributions there by Greg, again, another excellent contribution in terms of synonyms and antonyms. Siobhan, contribution in terms of information about Indigenous Australians, and Andrea. So thank you very much all for those excellent contributions. Please continue to do so, and if you're not contributing through UCrew, which would be the primary method of showing that you are engaging in the unit, please do so. And remember, of course, that 15% of your overall assessment rides on your contributions. So I'll continue to highlight some of these each week. The task for you at the end of this week is to improve your writing skills. In order to do that, you need to scrutinise your writing. You need to look at it critically, and you can invite others to do so. The writing that you prepare must be coherent, yet it must be comprehensive and consistent. It must be clear, and you must ensure that your writing is the product of care. So you need to take great care. So the 5 C's that we'll be talking about, you would have seen the elements of the 5 C's: coherence, comprehension, comprehensiveness, consistency, clarity, and care in the prescribed reading of the material. I do hope that you had an opportunity to read the reference reading, or at least 2 of the reference readings indicated in the study guide, but it certainly wouldn't hurt to go beyond that. Now, I mentioned that tonight I have an opportunity to, yet again, talk about issues about legal writing, and it flows through to statutory interpretation principles and to drafting, advanced drafting. I'm mindful, of course, that the students who choose to enrol in this elective are more than likely those students who are not only proficient in interpretation and drafting because they have an interest in the subject matter, but are likely to want to improve. So in that sense, I may be teaching to the converted. The 5 C's, of course, are important. They're referred to and described in terms of definitions in your study guides. There is the importance of producing something in your legal writing and your presentation that looks the goods. And of course, as an examiner, reading material that's presented to me, the first impression is critically important. Now, it's probably a factor of me having done this so long that I have a very keen eye for anything that just doesn't look quite right. I need to share something with you, and that is that I'm a very neat, organised person, not hopefully obsessively so, but to the point where on my desk, for example, if something, and there's some files behind me, but if there is something which is out of place, then I have trained myself to spot that quickly. I think there's a good reason to do that in law, because you will improve the work if you notice that something's out of place. In your writing then, material that's presented to me, I very quickly identify things that are out of place. I won't call it a superpower, minor superpower perhaps, but I can spot these things very quickly. And you might too if you're looking at others' work. But the risk is that if you're looking at your own work, you may unconsciously overlook something because it's just part of your work. So please look at it, look at your work critically and invite others to do so. One of the bugbears, which I do have, is when reading material, there's an inconsistency in the headings or the font or the style or the headings, the subheadings throughout. There's a good reason for me to be a little cranky with that. It's not just a matter of me being particular, overly particular. You see, one of the skills that we encourage you to develop in law, in the practice of law, is speed reading. Carefully and properly, the idea is that in statutory interpretation, we open a piece of legislation and we look at the headings, we look at the layout, we look for where are the objects, where are the dictionary provisions, and we then understand the Act to some degree in its entirety by looking at the headings, the subheadings, and getting a feel for the Act. In the same way, when you present material to me or to a judge, for example, in terms of written submission, you want to ensure that the reader has the opportunity to get a feel for your work, to see the overall parameters of your work, and a great way to do that is to look for headings. If your headings are inconsistent, if they're in different font, subheadings are mismatched, the numbering is wrong, it just makes it incredibly difficult to get an overall feel for that material from the outset. And that's a good reason then why you need to ensure that you maintain strict protocols about the way in which you present your work. It must be presented and formatted consistently and professionally. You simply can't move through a document quickly where you have inconsistency in headings, formats, and presentation. Once you start to drill down into the document, you look at the content, then of course you're looking for issues such as the tense, whether it's consistent, the tone, whether it's consistent, whether you've maintained a consistent voice, the active voice or the passive voice. I know you know that is a big bugbear of mine. I'll always encourage you to use the active voice where possible, but if you attempt to use the active voice, unless there's good reason to do so, do not switch to the passive arbitrarily. Now, I appreciate sometimes you will need the passive voice, but in the study guide, I think there's an excellent demonstration of that. And it says something like, and I'll just read from this, the respondent must reply to this letter of offer by the 15th of January. If the respondent agrees to this offer, the respondent must file a discontinuance notice with the registrar. The respondent goes on to say, just losing my place here, my apologies. The respondent must not comment publicly on the terms of this confidential offer. $10,000 will be paid by the respondent to settle the matter. So apart from my dreadful reading of that material, you would have seen that there was a consistency in the use of the active voice, and then suddenly, for no good reason, it switched to the passive voice. And when you're speed reading material, when you're getting a feel for it, that can really slow you down, and it's very frustrating. So remember, of course, the task is to inform your reader. As lawyers, you're professional communicators. The task of the communication, I guess, is simple. It is to inform the recipient as to your message. Which leads me then to the main theme of tonight's discussions, which is the plain English, or if you like, plain language phenomenon. This is worldwide. The Australian Law Dictionary, which I have, gives an entry for plain language, but not plain English. Plain English is now perhaps less common, but still used importantly and in many areas, and we'll talk about some of that tonight. So when we talk about plain English, we're really talking plain language, but you can use the terms interchangeably. Don't worry, we don't have to be too PC about that aspect of it. plain English, plain language, can, I guess, be identified in two ways. The first is that we're looking to remove that which is unnecessary, especially that which is language that I call pompous, legalese type language. We're seeing so much less of that now than we did 20, 30 years ago. That's one part of it. The second part is the work towards brevity in your language. Of course, there is a risk of being too brief. And to communicate effectively to all levels, we could summarize the law by reducing the content down and down and down until we get to a point where when someone says, what is the law of this country? If we were really being if we were really being brief, we could say 2 words, be good, or be excellent to each other. Fans of the movie will know what that is. But is that really going to get us very far? Probably not, because we've gone too far. It's too brief. So plain language, plain English, means balancing in terms of what we do. And of course, whenever we're talking about language, we need to look at the language used within the context of the surrounding circumstances. Sounds familiar from statutory interpretation. So that all these things are linked. Okay, I know I've been talking quite a bit. I'm just going to stop and remind you that we're looking for different techniques that will assist you and others in terms of producing better work. We've had some really good contributions throughout the unit so far. People have contributed with information that provides an opportunity to better produce documents. So, for example, I think I demonstrated the proofing tool in Word as a great way of checking your work and checking the Kincaid reading level, the idea being to get that down as far as you can in terms of the number. So, and we've seen some other good ones, so please keep them coming through. While we're on this discussion, does anyone want to share any good techniques, programs, websites that they've found that will assist them in their writing skills or their proofreading skills? I think people were talking about Google Translate. Microsoft have another version as well, Microsoft Translator, for example. Good way of reading out aloud or proofreading. Okay, as we proceed, if you think of anything, please let us know. Now, those of you that shared Introduction to Law with me will know that I've been speaking about these sorts of issues right the way through. And I'm just going to share the screen again, hopefully do so successfully, to remind you of some of the things that I did talk about in Introduction to Law. If you didn't study Introduction to Law with me, then this will be new to you. So if I've selected the right one, you might now see a little blurb that I wrote intentionally badly, verbosely, about a thank you for enrolling at Central Queensland University. And if you can see that on the screen, you'll see that the words there are many words, the sentences are very long, and there are many unnecessary words in that. You'll see also some bad habits that used to be a feature of legislative drafting, and that is lengthy sentences containing similes and antonyms quite unnecessarily. You'll see legalese, such as here and after, and repetition. So lots and lots of bad things in that material. And I think my suggestion was, instead of that, just simply say something like communicate simply and effectively. The other thing that you might recall if you studied Introduction to Law with me was the task that I would assign to students to redraft material that was verbose and do so in an efficient manner. So something like this, for example. And hopefully, again, I've got selected the right part of the screen to share. So that was, I think, from an examination. Reduced to 100 words, that which appears on the screen, and just take a moment to have a look at that, refresh your memory if you studied intro with me, or just have a look at that from scratch. Just read through it, pick up the main points. So the idea of an exercise like that was, of course, to ensure that you write with an efficiency of language. And the way in which you need to approach that type of task is to identify the main points, possibly using a highlighter, for example, and instead of all of those words, you might summarize what is written by saying something like, while enrolled at this tertiary establishment, every student is subject to prescribed ethical standards imposed by the university. Even that's bad because it's passive voice. The Vice-Chancellor may initiate disciplinary action against students for failing to meet ethical standards. The disciplinary committee will hear evidence in relation to the matter. The committee will notify the student in writing of the day and time of the hearing. And the committee will investigate the matters comprehensively, hear the matter fairly, governed by rules or principles of natural justice. The student has the right to seek legal advice. A student may appeal an adverse decision. So you get the idea that what we're trying to do is use words as efficiently as possible. And I think what I read to you, you could improve on that considerably. So far, the message, I guess, is improve your writing skills. I know I'm talking to the converted. Try to simplify your writing, but don't be too brief. Use technology where you can. And if you find some technology, share that with us. One of the reasons that we need technology to assist is this, that after you've written material, you become attached to it, and it's difficult to locate any mistakes and errors in the material. So you need to do something about that. Get a proofreader is a great way to do it. Leave it sit for a day, come back to it the next day is another good thing, or cut and paste your assignment or work into Microsoft Translator or Google Translate. Click listen, and as you're listening to it, it may be that the audio prompts you as to things that simply aren't working well. Now, there's an excellent piece of material in the study guide about the way in which the brain takes over in circumstances where inadvertently you possibly don't realise it. In the study guide, there was the passage, which I'll now just bring up on the screen, which demonstrated how well the brain can make amends for poor spelling or poor grammar, and why you need to take some precautions against it. So again, just bear with me for a moment. Sorry for the delay. Just sharing the screen now. And you'll see all the red lines in that passage. And of course, that's part of the technology that will assist you greatly. But if that's not too small, and I'll just increase the size, you might be able to just read that passage. Even though practically everything in it is misspelled, at least the main parts, you can still understand it. So what that does to my mind is highlight the fact that it is very easy to overlook material because the brain can take over, and you need to do something about that. Any questions, comments? We're all hanging in there, okay? I know I'm talking a lot, sorry. Okay, I'm sure that we have already discussed the Office of the Parliamentary Counsel. If not, if you haven't looked at the Office of the Parliamentary Counsel website, I now urge you to do so, particularly bearing in mind that our assessment piece, or pieces, is based around the sort of work that is done in the Office of the Parliamentary Counsel, because the OPC is responsible for drafting and publishing the laws of the Commonwealth of Australia. So you've got the state counterparts, but tonight we're just going to look at the Commonwealth legislation writers. So the Office of the Parliamentary Counsel might be known to you because it is the office that produces the authorised up-to-date versions of Commonwealth laws, and it's also the office that prepares draft bills for introduction into Parliament and a range of subordinate legislation, regulations, proclamations for government agencies, etc. So you can immediately see that by having reference to the OPC and the materials on the OPC site, you have a great opportunity to increase your ability to undertake the assessment piece. I'm just going to again share the screen and show you part of what you can find on that website. And if it's not too small, you'll see this is an extract from the website, and the heading is Drafting Resources. Drafting manuals, drafting directions, drafting templates, client advisors, legislative handbooks, and plain language. So the OPC website contains excellent material that will assist you in terms of what you need to do for the assessment pieces. The website contains drafting manuals and related documents. I'm going to start by identifying some of the things that are contained within the top left corner link, which are drafting manuals. The first is, and if you're following this on your computer, I'd urge you to go to the OPC website and follow along, as it were. So what you'll notice is, under the heading of drafting manuals, there is the OPC's drafting services, a guide for clients. And the purpose of this guide is to assist staff and agencies who instruct the OPC on drafting of bills and instructions and instruments. And it's a way of understanding the role of the OPC drafters, how they do their job. Now, I'm going to ask you to look at page 22 of the guide. This is the 6th edition guide. You'll find this within Chapter 4 under the heading of Drafting Instruments. You'll see a checklist for instructions. Now, I would have thought that would be a useful checklist for you to consider if you find yourself having to draft a bill for consideration of Parliament, for example, completely unrelated to your assessment work. So what does it do? It deals with the core issues. It identifies what is to be done and why, where you start with an explanation of key policy objectives, discuss why the legislation is necessary, and you talk about the remedy to a problem, and this is possibly including some examples. So you can see from that perspective that we're really talking about the explanatory memorandum, or in the state jurisdiction, the explanatory note. At page 22, it also talks about complexity, which is one of the themes for tonight as well. And it talks about the need for that which is less complex, that which is clear and simple, and some very useful tips that you might find useful for your assessment. Avoid specialist terms or technical jargon. You can't completely do that, but where you can, attempt to do so. Be consistent. If you have a concept, use the same word or the same phrase throughout the instructions. Do not be tempted to talk about motor vehicle, motor vehicle, motor vehicle, and then start talking about cars, because the reader will think you're talking about something else, or it will confuse the reader unnecessarily. And avoid unnecessary detail or complexity. Try to keep it to the point, stay on point, keep it brief. You'll see also in the drafting service guide some other material, details about commencement, and these are all checklists, if you like, on what you need to include in your draft bill for the assessment. Number one, you need to have something about the commencement. And there's some options there. For bills, the options for commencement are the day of assent, or some other specified day, or a day to be fixed by proclamation, or on the commencement of a related piece of legislation, or the happening of some other event, such as Australia entering into a treaty. So when you draft legislation, you need to have some mechanism for when it commences. Now, I know you'll say, but in the Acts Interpretation Act, it already prescribes that. But bear in mind, it's OPC policy, and I think it should be your policy, if you're drafting material, to specifically state the date of commencement or the mechanism for doing so. The next thing to remember is whether or not the act that you draft is intended to bind the Crown. You'll remember there are presumptions in that regard. Also, does your legislation purport to have extraterritorial effect? Does the bill apply externally? The next is compliance with obligations. If the bill that you draft does impose obligations, then you need to follow through with this and think about, are there consequences for non-compliance with the obligations? For example, if there's a loss or denial of a benefit, or civil or criminal penalties, you need to state that. And then you need to perhaps go further and say, are there monitoring and enforcement powers that you need to include in your legislation so as to confer power on the executive to check for compliance? The next thing that the guide prompts you to do is to decide whether you are conferring power to make administrative decisions on the executive. Is there to be an administrative review of the decision? A merits review, for example, of the decisions made by the executive. Bear in mind that judicial review is guaranteed by the Constitution, so you can't exclude that. But you may or may not choose in your legislation to incorporate a merits administrative review mechanism. So in the Commonwealth level, the review, I guess typically would be the Administrative Appeals Tribunal. In the state jurisdiction, say Queensland, it would probably be the Civil and Administrative Tribunal. But there are other tribunals as well that conduct merits reviews. The next is, in your checklist, power to make instruments. When you draft your legislation, do you expect to confer the power on the executive to make subordinate instruments as a result of the legislation? And you need to specify that in the bill. So in the guide, it specifies 9 or 10 different things that you might incorporate into your legislation that will allow for the existence of subordinate instruments to be created. Which there's also some commentary on delegation. Are you going to confer powers on a body or a person? And if so, how do you do that? How do you incorporate that into your legislation? So this guide gives you some information and assistance in that regard. The next thing you'll note in the guide is that the OPC does promote the use of plain English, but it does acknowledge that there are different ways that you might achieve effective communication, and plain language is one of those, but it's a very important one. And of course, the OPC is committed to removing the old-fashioned language, as you should be as well. Now, the guide also then talks about some specific techniques to aid comprehension. Have a look at paragraph 141 in that regard. And you'll see at paragraph 141 of the guide that it says there are various other techniques that OPC drafters use to help readers understand legislation. Now, when you're drafting your legislation, you should follow these rules as well. Simplified outlines, objects provisions. I'm sure you'll all have objects provisions in your draft legislation. Notes, this can explain the purpose or origin or operation of the provision. Examples are always a good idea, but you don't have to. And tables are useful for collating large volumes of information. Now, in your draft legislation, don't feel compelled to include all of these things. I suspect that you'll have an objects provision, but you don't have to go to incorporate the others. It's not as though you'll necessarily get extra marks because you include examples or tables. Mind you, you might if they enhance the comprehensibility of the legislation. That may assist. There's also some notes in the guide as to the commencement provisions and a reminder about explanatory memorandum or explanatory statements, that there must be an explanatory memorandum for a bill. The explanatory statement applies to legislative instruments. Okay, so are there any questions then about the first of the drafting manuals that I have referred you to in the material from the OPC? I do hope that you can find this material useful, and if you've already found it and you've gone through it, my apologies for covering areas that you've already dealt with. Any questions, comments? The threat, of course, if you don't ask questions or make comments, then I just keep going. All good? All right. So the next thing is the OPC Drafting Manual. Again, you'll find this in the that section, that drafting section. And the drafting manual is a little more specific. So the first was a guide to clients. The drafting manual provides information that might be useful to you. I'm going to refer you to paragraphs 68 to 71 first up, which deals with issues to do with definitions contained in legislation. Some important rules specified there. One of the interesting ones is, and I like this, don't overuse or misuse definitions. If you overuse definitions, it can affect the readability. So use a definition carefully. I mentioned before, if you have a word or a phrase, use it consistently. And the approach from OPC is to adopt the one expression, one meaning approach to drafting documents, and try, if possible, to ensure that the same expression has the same meaning in different parts of the act or the instrument. There are some naming conventions. Have a look at paragraph 82 in that regard. Whilst the naming conventions are not common to all jurisdictions, some states and territories have their own, there is definitely a naming convention for numbering sections in Commonwealth legislation. And you'll see there it's section, subsection, paragraph, subparagraph. Have a look at paragraphs 96 and 97, which deal with dictionaries and style manuals. And the OPC relies on the Macquarie Dictionary and the Style Manual. And if there's doubt and inconsistency, go with the Macquarie Dictionary. Now, it seems to me that that means that if you're going to refer to a dictionary, non-legal dictionary, refer to the Macquarie Dictionary as well. Have a look at paragraph 99 that deals with gender-neutral language, and 123, which deals with tribunals, particularly administrative review tribunals, and in particular the AAT for merits reviews. in the Commonwealth sphere. Then jump ahead to paragraphs 284 and 285, which deal with penalty provisions. So some very good guides there as to how you should draft your material. There is a protocol that we adopt when describing a penalty. And have a look at a piece of legislation that does impose penal provisions, and you'll see the way in which it's written as a note, if you like, at the bottom of the section. And also, very importantly, if you're going to incorporate some sort of penalty regime into your legislation, do not include a dollar value. That went out some time ago. We now use penalty units at the Commonwealth level and the state level as well. All right, again, I'll invite any questions, comments. You're doing well, we're getting closer. The third manual in the website is the Amending Forms Manual. It's a very substantial document and it deals with general rules, specific rules and checklists. So if your piece of legislation is an amendment legislation, you might want to have a look at that drafting manual. And finally, within this area of drafting manuals is the OPC Plain English Manual. So I guess that begs the question, why draft simply, if that's what the theme of tonight is? Well, it's to ensure that what you write, what is written, is easy to understand. If, as was the case in years gone by, the law is hard to understand, it adds to legal costs, it adds to administrative cost, and importantly, it means that it's not fair for individuals. So when you write your material, do so in a simple style if you can. Make sure that the reader, which will be for assessment purposes, me, can understand it. And that's all part of simple drafting. Have a look at paragraphs 13, 14 and 15 in that regard, which provides some valuable information about the techniques of simple drafting. The manual uses the word technique. There are a number of techniques and there are 4 broad classes of techniques. The first is plan your draft legislation properly, and you'll see that's in chapter 2 of the manual. Develop good writing habits by following rules that have developed by good writers. That's dealt with in chapter 3. Number 4, the third one is avoid bad writing habits by rejecting traditional forms of legal expression, that which is obscure or long-winded. That's in chapter 4 of the material. And use various aids to understanding. Have a look at paragraph 15, which talks about general principles drafting. So this is the style used when you deliberately state the law in general principles and you leave details to be filled in by the courts or by delegated legislation or some other way. So it's very easy to read, be excellent to each other is very easy to read, but it's fuzzy and it needs to be filled in with detail. All right, so I mentioned some of the chapters. Chapter 2 deals with planning the draft. Some excellent information there. When you're preparing your material, concentrate on substance instead of form initially. Identify the goals. Chapter 3 deals with good writing habits. And have a look at paragraph 50. It says, sometimes you can decide who most of the users of the law will be and then deliberately aim at them as part of your drafting process. For example, the Social Securities Act 1991. However, we usually write for a variety of users and all our laws have to be read by administrators, members of Parliament, lawyers and the judiciary. We're getting close to the end, so thank you for your patience. I'll just highlight a few extra points out of that OPC Plain English Manual. Do have a look at paragraph 52. This is a really important paragraph. It has excellent examples, and the theme of that section is construct your sentences simply and logically. And the ways to do this, and I'll highlight them. Use the positive rather than negative. For example, a form is valid only if the taxpayer has signed it. Don't say a form is not valid unless the taxpayer has signed it. You see how it's so much easier in the first instance? Avoid double and triple negatives. But remember that sometimes a double negative does not equal a positive. Avoid complicated or unusual grammatical constructions. Use the active voice rather than the passive voice. The authority serves a notice. Don't put in your legislation, a notice is served by the authority. It's just harder to read. Put adverbial phrases after the verb when there's no ambiguity. For example, this is what you want to say. The Minister may issue the licence within 30 days after receiving the application. Nice and simple. Don't complicate it by changing the simple wording. Don't say, the Minister may, within 30 days after receiving the application, issue the licence. The first one was easier. Go with the easy one. Do avoid excessive shortness if it means that you are denying understanding. Keep related words close together if possible. Avoid noun strings. We see this a bit. For example, don't say childcare delivery programs grants. Say instead, grants for programs for providing childcare. I hope you see the difference there. I won't go through the rest. I'll leave you to do that. But that is section 52 is a really interesting and valuable way to go. Have a look at 54 and finally 57. Short sentences. There are some ways of keeping sentences short. Be ruthless in eliminating unnecessary words. Keep lengthy qualifying clauses out of the main proposition. Deal with them separately. Avoid string of alternative words, and don't make verbs into nouns. Use the verb form results in fewer words, and the words are usually shorter. So, for example, say, a person may apply, rather than a person may make application. Extra words, don't need it. Okay, well, you've been really patient. Thank you very much. I know I've talked a lot tonight. Before I leave, and that's all for tonight, are there any questions? And the idea, and thank you, Neil. So the idea tonight was to reinforce some of the things that we know as good habits, but also provide you with very specific information that will assist you in your assessment work. Okay. All the best. We'll see you next week. Bye then.